Have a seat, Pat.
Thank you.
Well, now that you have all your new employee paperwork signed, let's get you started on some cases.
I'm really looking forward to working with you. Where do we start?
Let's spend a little time reviewing the basic elements of a negligence case. As you know, we represent a lot of car wreck cases, medical malpractice cases, and some legal malpractice cases, which all involve some form of negligence. So, let me ask you, what are the basic elements of a negligence case?
Duty, breach, causation, and damages.
Very good. You obviously studied this in school. Let's pretend I don't know anything about a negligence case. Let's review the basic elements. Start with duty. What does that mean?
A duty is a legal obligation one person owes to another. Before you can have a negligence case, you have to prove that the defendant owed a duty to the plaintiff.
Wouldn't we all owe duties to everyone?
No, actually, there's a lot of situations where one person doesn't owe a duty to the other, so if they fail to act, there couldn't be a civil case for negligence. You first have to establish what the duty is and then prove the second element, which is breach.
Okay, tell me about breach.
Well, once you've established that the defendant owed a duty to the plaintiff, then you have to prove that the defendant breached that duty. All these elements build on top of each other. If you don't have duty, you don't have a case. If you have duty but the defendant didn't breach it, you don't have a case.
How do we prove the defendant breached the duty?
We show he acted improperly or negligently. Violating the standard of care for a doctor is one, or showing that the defendant acted recklessly is another. If the defendant's a motorist, for instance, and he violates the rules of the road, it's a great way to prove breach.
Okay, so far so good. Tell me about the third element of a negligence case.
Causation, which is a tough one because in civil cases you have to have proximate cause.
And what's that?
Proximate cause is proof that there's a direct factual link between what the defendant did or failed to do and injury to the plaintiff. You really have to have a strong connection between the two for a jury to find the defendant liable to the plaintiff.
Give me an example.
Okay, say this guy runs a red light without stopping. He hits our client. We have duty because all motorists owe a duty to all other motorists to obey the rules of the road. The guy breached the duty by running the red light, and his failure to stop is a direct connection to injuries suffered by our client.
Okay, tell me about the fourth element.
Damages. Once you've proven the first three, then and only then can you find out what the client's injuries are. You can ask the court to force the defendant to pay for things like all medical expenses related to the accident and lost time from work, pain and suffering. And the one I can never remember where the spouse files to.
Loss of consortium.
Yes. That's where the spouse files a suit against the defendant for causing injury to the husband, and because the husband is injured, he can't perform the same activities he'd be able to before the accident.
That's pretty good, Pat. What can you tell me about special, general, and punitive damages?
Special damages are damages that are directly related to the injury and have a specific dollar amount.
Okay, give me an example.
Medical bills. The plaintiff can sue for things like all medical bills, physical therapy, things like that.
Okay, so what about general damages?
Those are damages that are a little bit more like pain and suffering. They're a little harder to put a dollar figure to. I mean, there's no bill you can point to for how much pain a person has suffered due to an injury, so they're called general damages.
So far, so good. Punitive damages.
That's easy. Those are damages that the court inflicts intending to punish the defendant. They're typically for things like gross negligence or reckless endangerment, but you don't find a lot of those in negligence cases because they are, by their very nature, non-intentional actions.
Excellent, Pat. Where did you learn all this?
I reread my college textbooks before coming here this morning. Thought you might ask me something like that.
Pat, I think you have a real future here.